resolution. It looks like we have 4 really interesting presentations. One other note that I forgot in my previous spiel for the presenters, I'll give you a notice in the private chat function at 10 minutes so that you have 5 minutes left, and then again at 13 minutes that you have 2 minutes left. So in case, just to keep you guys on track, look for that in your private chat box. But to start, we have a presentation entitled Arbitration Under Pressure, Accounting for Firms' Use of Mandatory Arbitration. We have all 3 presenters here today, Ariel Avgar, Ryan Lamare, and Alex Colvin. And so I will hand it off to them, and you're on the clock.
Sorry about that. Can everyone see the slides? Can you see our slides?
Yes, yes. I think we can all see it.
Okay, awesome, great. So thanks, Brad. Thanks for chairing this session. Thanks to ILERA for putting this program up virtually. We're excited to participate in this session. My co-authors to this work are Ryan Lamare and Alex Colvin, as Brad noted, who are both here. Ryan and I will split the presentation itself, and then we'll all engage in the discussion. And since we didn't rehearse this, I'm going to try to leave Ryan with as many minutes as I can so he can talk about the results. So our presentation is about the driving factors for mandatory arbitration in the US. And I'll just set the stage a little bit for our non-US folks for whom this isn't a feature of their dispute resolution system. Mandatory arbitration or pre-dispute mandatory arbitration is the ability of employers to require that employees, as part of their employment with the firm, sign a waiver requiring them to use mandatory arbitration, to use arbitration as a way to address all claims with the employer, including statutory claims. And this element, which can be quite controversial and surprising to folks outside of the US, is a defining feature of the US dispute resolution system. We know that there's widespread use of this practice by US firms, and Alex Colvin in his recent work has estimated about 55% of firms make use of this ability to require employees to sign such waiver, almost double, or just about double the proportion of firms requiring employees to do so, or of employees falling under such requirements in the early 2000s. As you might imagine, there's been quite a bit of scholarly and policy debate around this practice, both from a procedural standpoint. Do employees really get the same procedural fairness and protections, due process protections in an arbitration, in a private arbitration setting, as they might get in the justice system, in the courts? And there are also a whole host of questions about the substantive fairness associated with this dispute resolution practice. Are the actual awards handed down through arbitration similar to those that might be handed down through the courts? And there's a large body of research examining this issue. Proponents of mandatory arbitration claim that it's an accessible, cheap, efficient, effective method to resolve employment claims and conflicts and disputes, providing more access to employees given the cheaper cost. Opponents raise the concerns that I just noted about procedural fairness, about lack of protections, a large body of research looking at concerns about repeat player effects when the same arbitrator deals with the same employer. And so there's a great deal of both, again, scholarly and policy debate around this practice. Sorry. And there's been some additional recent attention to mandatory arbitration based on the role that it plays in sexual harassment or sexual assault claims in the workplace. Having these types of mandatory arbitration clauses limit access to the court system around these issues. some high-profile firms have moved away from use of mandatory arbitration. A couple of years ago, there was some collective action, a walkout on the part of Google employees, pressuring Google to move away from the use of what is in sort of layman's term referred to as forced arbitration. And this public debate around mandatory arbitration has raised sort of the question, what are some of the driving factors that lead to adoption of this practice? Given the debate, given the concerns, what are some of the factors or organizational related characteristics that lead to adoption? And that's the fundamental question that we ask in this presentation. We have a good understanding of the rise of mandatory arbitration through the work of many people on this session, but we have far less substantial evidence, or we have weaker evidence about the types of firms that are using mandatory arbitration. So what are the organizational characteristics driving this practice? And we know less about the strategic orientation or sort of the logic that's driving the adoption of these practices. It's important to note that in contrast to arbitration in the union setting, employment arbitration for non-union employees is almost entirely driven by the employer choice or employer decision. And as such, we want to know, well, what's driving variation, given that employers have the ability to adopt these practices. A substantial proportion of firms are making use of this practice, but a substantial proportion of firms are not. And the question then becomes, what explains this variation? And so the motivation for our study is to try and understand sort of adoption drivers. And we look at both environmental structural factors, size, union status, subsidiary or not subsidiary, and also strategic factors that help to explain adoption, to try and start to develop a theory of a mandatory arbitration adoption. And I've noted the type of factors that we look at. And we're also hoping to try and develop some theoretical framework around the types of organizations and how they're linked to employment relations approaches, not just the specific organizational characteristics, but are there certain employment relations approaches that are more likely to drive adoption than others? We draw on two bodies of research in theory for our work. First, there's been a long-standing body of research looking at the link between organizational factors and adoption of mandatory arbitration, of practices specifically, not of mandatory arbitration. So in the early 2000s, late 90s, there's a great body of research looking at, was it union substitution or litigation avoidance or other factors that were driving adoptions of practices like mediation, arbitration, and other dispute resolution practices. We extend this research by including some additional factors that haven't been explored in great detail. Compensation, for example, subsidiary status, and other factors that Ryan will talk about. And a second body of literature that we draw on, and there'll be a presentation today that looks at some of these questions, is the role of strategic choice in adoption of dispute resolution practices. And we extend this research by looking at competing organizational logics for the adoption of mandatory arbitration. So I'll just highlight sort of the key theoretical contributions of this work and the hypotheses that we set forth. First, we argue that both structural environmental factors, again, union status, size, subsidiary status, are associated with the adoption of mandatory arbitration, and strategic factors, choice made by employers to complement existing employment relations approaches. The second contribution is that we look at both high road employment relations approaches and low road employment relations approaches. As you might imagine, the debate around mandatory arbitration suggests different organizational logics. So one is the use of this practice is primarily done in low road employment relations practices for low paid, low skilled workers. That's sort of one version of the use of mandatory arbitration. And the other, more consistent with proponents of mandatory arbitration, is that it's used for high skilled, highly educated workers who have more of bargaining power in their relationship with their employers. And so we should be less concerned about the procedural and substantive fairness related issues that I brought up earlier. In doing this, in both looking at structural and environmental and structural and strategic features, and looking at both high road employment relations practices and low road employment relations practices, we think we add to the complexity and nuance of what's driving the adoption of mandatory arbitration. I hope I left enough time for Ryan, but I'm going to turn it over to Ryan to discuss.
Yeah, thanks very much, Ariel, and thanks very much to everyone for attending. So I'll just jump in with some of the data and findings. So our data come from a nationally representative survey that was conducted between March and July of 2017. It was administered using a sample drawn from Dun & Bradstreet's database of companies stratified by state, and we're looking at firms with over 50 employees. We surveyed the HR manager, or person most closely responsible for onboarding employees, and the survey ended up with about 1,530 targeted responses with a response rate of about 47%. So we have 627 total responses. So the dependent variable here is mandatory arbitration, and how that's asked is whether their employee handbooks, personnel policies, or employment contracts contain, quote, an agreement or provision for arbitration of legal disputes with the company. We then have several independent variables: firm characteristics, which is subsidiary, union status. So subsidiary is, are you a subsidiary of a parent corporation? Union status, size of the company, the industry, and the state that they're in. Workforce characteristics, which we define as turnover rates, employee education levels, and working conditions, which is pay and full or part-time status. So high pay or low pay and full or part-time status. So here's a little map of the sample. You can see the geographic distribution. If you go into Google Maps, you can actually, if you have addresses of companies, or whatever addresses of any individual in a sample, you can actually create Google Maps that will allow you to drill down all the way to the street level. So this is just giving you a sense of what the sample looks like. If this were on a Google browser, we could actually scroll down and look at the intricate details of each of these companies. But this gives a sense of the overarching representativeness of the companies. So just descriptively, you see that mandatory arbitration falls right at 54%. So 53.9% of all respondent firms say they had answered yes to that question that I read out earlier. They say, so we classify those as having mandatory arbitration. About a third are subsidiaries. About 14% are unionized. It's a smaller sample in terms of firm size, so only less than 5% have greater than 1,000 employees. When we look at some of the sort of workforce practices or characteristics, we see 36%, about a third, require non-compete clauses in their non-union workers. Many of them have at-will employment. The vast majority have at-will employment. The turnover rates are relatively stable at the companies. Only about a quarter have greater than 25% turnover. And it's a pretty reasonable mix of part-time versus full-time and low and high employee education. About 60% of them are low pay, and the largest location is California. Largest industry is services. Okay, so just to show you the findings here, what we see. So when these are predicted probabilities or marginal effects after we run a probit model, just to give you a sense of the increase or decrease in arbitration. So subsidiary and union status significantly increase the likelihood of arbitration by around 20 to 30%. Firm size does not matter. Non-competes are significant and positive for the presence of non-competes are significant and positive for arbitration, but at maybe a slightly lower rate than the subsidiary and unionized status. High turnover is negatively affects mandatory arbitration. So low turnover actually matters more for having mandatory arbitration. Part-time employment status is positively associated with arbitration, and low pay is also positively associated. We then ran, those are main effects, we then ran interaction effects, and we found a couple of interesting interactions. One is that low turnover, low pay companies are significantly more likely to have mandatory arbitration. About 65% of the sample of low turnover, low pay had mandatory, compared with like high turnover, low pay, which is down below 45% of the sample. So turnover and pay seems to moderate this relationship. And then the second moderator is education and at will. So highly educated, firms with highly educated workers that are not at will, that are on long-term, probably long-term employment contracts, are way more likely to have mandatory arbitration at about 72% or so, relative to other at will and education statuses, which all sit around that 45 to 55% range. So just to wrap up, discussion and implications of our findings. So we think that we see pretty clear evidence that mandatory arbitration is driven by environmental factors, but it's also driven by strategic choice. What might look like a low road strategy that involves low pay, low educated, and low pay, low educated, part-time workers subject to non-competes actually gets more complex as you look more deeply into the results, as you run interactions and look for moderating effects. And so there may actually be some high road drivers as well, things like high education and low turnover at these companies. The overall implications are that we need to have a much more nuanced understanding of mandatory arbitration that is typically given by proponents or opponents of the arbitration process in the media and elsewhere. Thanks very much. Sorry, Brad, I know I'm 3 seconds over.
No, it's all good. Thank you, Ariel, Ryan, and Alex. And so next up, we have David Nash and Deborah Hann, my apologies, looking beyond ADR, looking for integrated conflict management systems in the UK. You're on the clock.
Right, I better hurry up and share my screen then, hadn't I? Okay, I'm presuming everyone can see that. Okay, so thank you very much, Bradley, for introducing us, and thank you everybody for coming along today. This is a project I've been working on with Dave for a number of years now, but the findings that we're presenting today come from a 2018 study that we undertook of organisations within Great Britain. The survey covered a raft of issues related to workplace disputes, but what we would like to look at within that today is the concept of integrated conflict management. So for those of you who perhaps aren't aware, and for those of you who are, a quick recap, a definition of an ICMS is a systematic approach to preventing, managing and resolving conflict that focuses on the causes of conflict within the organisation. And actually, if you look through the literature, there seems to be a growing interest in this as a concept over the last decade. There's a few references on there, but it's not necessarily a new field. Lipsky and Sieber wrote about this kind of change in company mindset towards conflict nearly 30 years ago now. So this isn't necessarily something that is new, but it does seem to be gaining pace in terms of people wanting to look at it and examine it and see whether it exists in reality. So whilst people are interested, there is caution around whether ICMS is actually playing out in practice. Lipsky in 2014 drew from his survey on the Fortune 1000 firms, and 67% of them said that they had some kind of conflict management system. But actually, when you got into the details, that was perhaps not as clear cut as the managers perhaps perceived it to be. And Lipsky talks about this as an emerging phenomenon rather than as widespread as that number would suggest. And that evidence is backed up by a study done by Katz and Flynn in Florida, I think it was. What's clear when you look at the literature, though, as with much of the research around dispute resolution, is studies on ICMS outside the US are extremely rare. And where they do exist, they seem to be very narrow in focus. So there was a great study done by Paul Latreille and Richard Saundry in the UK, looking at the NHS. So single study, single organisational case study. The other bit of research that I know about that kind of hints at this outside the UK is a survey done by Roach and Teague in, the survey was actually done in 2008. And within that survey, they found no evidence of this kind of systematic approach to conflict within organisations in Ireland. So just to define exactly what we mean, and this is a very prescriptive approach to integrated conflict management, there are a couple of definitions, but this is one that we took from the Society of Professionals in Dispute Resolution, that actually the Society includes a number of the key authors that have been referenced on the last slide and probably will be referenced in the rest of the presentation as well. So it includes 5 key characteristics. The concept that conflict management is all-encompassing, and by that I mean it's company-wide, it applies to all employees, and it covers all types of conflict within the organisation as well. It isn't narrow in focus, it is very broad in focus. The second characteristic is that of a conflict-competent culture. So this is where the culture accepts and welcomes dissent within the organisation. So training would need to be given to adjust people's mindsets to how to respond constructively where conflict occurs. The next thing is that there's multiple access points. So employees in key roles are trained in how to react when conflict occurs. And then when conflict does occur, the employee doesn't need to go through HR to get that conflict addressed. And if they go through, for example, religious counsellors or trade unions, they aren't then bounced around different parts of the organisation to get their conflict addressed. The next one is options and choice. And this is giving, exactly as it says, giving employees an opportunity to choose how they want to address and resolve the conflict within their organisation, and actually to give them a choice to move between options as well. So they may start with a grievance procedure and also bring into that a mediation approach. Finally, there's the idea of support structures, and this is the concept that other elements within the organisation would champion and underpin the breadth and depth of conflict management within the organisation. So you would expect senior managers, for example, to be championing the approach to conflict management, and you would expect to see some of the broader HR practices developed in such a way that they underpin and support this approach to conflict management. So broadly, the essence of these characteristics then are that this is a bigger picture approach to conflict management, and that there's relationships between parts of HR and parts of conflict management in a systematic way. So it gives you, as Lipsky and Avgar say there, a holistic and comprehensive approach to managing conflict, that this is about consistency with broader goals and consistency within how you're trying to achieve those broader goals. And again, Lipsky and Avgar, it's very unnerving quoting people who you know are on the call with you. Lipsky and Avgar talk about this as kind of the most sophisticated form of conflict management. So what we would like to do within this paper then is take these ideas and see whether actual ICMS exists using survey data, so using quite broad data, see whether ICMS exists within Great Britain or the UK, we've written there. We'd like to consider the degree to which the characteristics of ICMS are evident within the organisations that we looked at, and then we want to consider the extent to which organisations perhaps demonstrate a holistic approach. So to give you an idea of the data that we're using, this is a survey that we sent out in 2018. We sent it out to about 5,000 organisations within Great Britain. By that I mean England, Scotland and Wales, but not Northern Ireland. And it went to organisations with over 20 employees. And we used Companies House data to collect our sample. We stratified by size and sector and received 400 valid responses back. The survey that was sent out was an instrument that we'd spent quite a lot of time adapting from the survey I mentioned previously that Bill Roach and Paul Teague had sent out in 2008 to the Republic of Ireland. But we had built on that and developed that, added extra questions and changed quite a few questions based on feedback that they had helpfully given us. Within that survey, we also distinguish between 3 different forms of workplace disputes. So we talk about individual disputes, which are those between individual employees and their employers, inter-employee disputes, so that would be between teammates within an organisation, and then group disputes, or what's commonly known as collective disputes between different groups of employees and their employer. So these are the findings then. If we take the characteristics that I showed on an earlier slide, what you can see there is, to a degree, a mixed bag. So some of the elements are there. There's evidence that conflict is all-encompassing in approaching half of organisations, that there are multiple access points in over half of organisations, and that in over half of organisations, employees are given choice in how they approach resolving disputes that occur. But actually, equally, there's lots of lack of evidence of ICMS characteristics. So UK organisations are not showing any competency, cultural competency in addressing conflict, nor is there much evidence of kind of broader support structures to underpin and support the development of a systematic approach to conflict management. So if we take that then and we move it and look at, just checking I've got the right slide up, yes. If we look at what that looks within each organisation, actually you can see there's probably minimal evidence on the surface for ICMS within Britain. So most organisations maybe demonstrate 1 or 2 of the ICMS characteristics, but certainly if we're talking about 5 characteristics, there are very, very few organisations that demonstrate that they are operating at that level. So the idea at a superficial level that ICMS exists in Britain is one that we would question. However, if we start thinking about the second slide that I showed around it being a holistic approach, and thinking about other parts that may exist and show evidence of a move, if not a reaching the end point, of a move to this systematic approach, then perhaps we might start questioning whether there is no evidence at all. So if, for example, we're talking about broader evidence that, thank you, I presume that's, sorry, I've turned my chat off, that's the problem. Okay, thank you, Brad. So if we're talking about broader evidence that organisations are developing practices that suggest that they are thinking more holistically about dispute resolution and the systematic approach, then we started by saying, well, you know, do they have ADR in their policies? What does that look like? To what degree is ADR present in their policies? And what you can see there is, if we look at the light blue bars, is that actually there's very little evidence that in policies UK organisations are demonstrating ADR within their organisations. So the graph is split into 3 separate levels. The top 2 bars there are what we would consider not ADR, the traditional approaches, the disciplinary and grievance approaches to disputes. The next set of variables there are what we consider as internal ADR. So internal approaches, keeping it within an organisation. So internal mediation, discussions facilitated by HR review panels. And then the bottom 3 is, or the bottom set is where you bring in externals to help with ADR. And as you can see, those light blue policy, the evidence of inclusion in policy is very, very slim. But if you look at it from a usage perspective, actually you see a much greater usage of ADR within the UK. And that goes across pretty much every one of those categories. And internally, there's quite high usage of ADR policies. So what we would suggest is that in practice, in policy, there may not be this holistic approach written down, but increasingly we're seeing a holistic approach in how people approach dispute resolution in practice. And there is quite a big distinction then between policy and practice. The next, going too far, the next piece of evidence we kind of looked at then is thinking again holistically. not just do they have ADR, not just do they address dispute resolution in quite an advanced way, but how do broader practices underpin that? So we started looking at what other HR practices do these organizations have, and how does that relate to their approach to conflict management. With this one, we went with a much narrower definition of ADR. It's the one that we probably all agree on is ADR. Some of the others, we can have a debate as to whether they are actually ADR. So we went with mediation, and we looked at HR practices that would broadly sit in line with strategic approaches to HR, the high performance work system type approaches. Thanks. I'm just finishing up. So what you can see there is quite clearly where there's high levels of mediation or evidence that ADR is occurring, you tend to find, or the other way around, you tend to find HR practices, strategic HR practices in organizations where ADR is occurring. It's more common that that is the case. So again, we're suggesting that there is this holistic relationship, or this relationship between how organizations are approaching things at a holistic level, if not a prescriptive level. So then just to draw some very quick conclusions, because I think I've probably got about 30 seconds left. At a superficial level, we would argue that there is no systematic evidence for ICMS at that prescriptive level, but actually if you start to dig deep into that, there is evidence that there are steps towards developing a broader approach, and numbers of organizations are starting to show signs or elements of ICMS within them. If you reflect on ICMS as a holistic and comprehensive approach, then actually possibly there is evidence of growing ICMS within the UK. And I think I will leave it there. I'll stop sharing my screen now.
Great, thank you, Deborah, with 20 seconds to spare. Thank you. So we will keep the ball rolling here. So we'll move on to our third presentation by Benjamin Hopkins and Kristine Olson, entitled Self-Managed Conflict Resolution, a Case Study of a Flatline Hierarchy. And so I'll leave it to you, and off you go, and you're on the clock.
Thanks, Brad. How you doing?
Good.
Good. I am going to do this from notes rather than from slides, so you get to look at me talking through all this. Good morning, everyone over in North America. Pranam to everyone down in South Wales. I'm based at the University of Birmingham. During lockdown, I've had to come back to our primary house, which is in Wales. It does mean I've got to give one of the odder working from home caveats, is that my house is in a low-fly training area for the Air Force, and they've decided that this afternoon is the best time to be sending over F-35s every 5 minutes or so. So if I see a couple coming down the valley, I'll quickly mute my microphone to save people's speakers, and if they've got headphones on, to save your ears. So if I go quiet and do an impression of an airplane, that's what's going on there. So this paper is titled Self-Managed Conflict Resolution, a Case Study of a Flatline Hierarchy. Kristine Olson, who sadly isn't at the conference, is very much the expert side of the conflict resolution bit. But we've come together to look at this paper because most of my work that I've looked at previously has been looking at hierarchy in organizations, and particularly around informal hierarchies and how they come about, particularly people doing the same job but employed on different types of contracts, so particularly between permanent workers and seasonal or temporary ones. And increasingly, because most of my work is based in food manufacturing, how that's intersected with migration. So a lot of my previous work has looked around what happens when you have a lot of migrant workers, particularly from Central and Eastern Europe, working in food manufacturing in the UK. So one of my other projects I was looking at prior to all of this was what's going to happen to food manufacturing in the context of Brexit. I was looking through my notes for that the other day. I'm maybe sort of quite nostalgic for when Brexit was the biggest disaster that was coming into the UK. But I got an opportunity before all of this to go and do some research with a food manufacturer over in the Western United States, and a really, really interesting case study company for anyone who looks at hierarchy, because this is an organization that claims under the level of the CEO and owner, they don't have any formal hierarchy at all. So everyone is supposed to be employed on an equal basis there. So again, this is a company based in the food manufacturing sector. They are over in the Western US. It's a fruit picking, packing and processing organization. We came up with the highly original pseudonym of Fruit Co. For this, based in a fairly rural area, as you'd expect for a fruit processing plant. They have around 24 permanent workers, supplemented by up to around 120 seasonals. And one of the reasons I was interested in this case study is that they have a lot of migrant workers. So what I wanted to look at was some of the similarities that you might see with food manufacturers over in the UK. So it tended to be that these seasonal workers were either Mexican or US citizens of Mexican descent, whereas the permanent workers tended to be white US citizens. And it was quite a surprise as someone from the UK to go over there and hear ethnicity being discussed sort of quite openly as a dividing thing between those different groups of workers. As well as the flatline hierarchy, they subscribe to the ideas of self-management. So in a way, this sounds like it'd be a good thing. It distributes power down throughout the organization to the different workers. So they're supposed to manage their own tasks. Also, though, any kind of conflict resolution is supposed to be self-managed. So the process for that is that if two workers come into some kind of conflict, they're supposed to try and resolve that issue by themselves. If they're not able to do that, they then broaden this out to get a group of between 3 and 10 people who work in a similar area to try and resolve that. At a push, they then might move to what might be considered more of a managerial role to act as an arbitrator. And then the final part is that they could go up to the owner if they're not able to resolve it between themselves. So quite a different approach to what you'd expect in a standard hierarchical organization, where really dependent upon sort of either status or power, that would be the main influences on the way that those conflicts are resolved. So we might think in terms of these conflicts being either task-based or relationship-based. Of course, relationship-based in general, where you don't get on with the person with whom you're working. Task-based, more around workplace issues. So when we come to some of the findings, they're divided down that way. But like we said, the way that these are resolved depends to an extent upon the status that people have within an organization, so the official status that they have. And by removing those official statuses, by removing hierarchy, it means that power and unofficial forms of power become an awful lot more important in the way that that those things are resolved. So we might think in terms of some jobs where people have quite low levels of status but quite high levels of organizational power. That might be drawn upon the networks that they have. It might be based upon specific organizational knowledge that they have, and previous work has suggested that it's actually the people who have quite low status but higher levels of organizational power that report the most conflicts in their workplaces. So analyzing some of the findings that we had, I spent quite a lot of time with this organization, so quite a lot of time gathering informal data, some time, with informal interviews, just observation, finding out how the plant really worked, how people work together, what could be some of those forms of conflict, and then with some more formal recorded semi-structured interviews as well. We tried to analyze that using the dual concern model. So thinking about essentially the levels of concern that people have either for themselves or for the other person in that conflict. Okay, so if we go to the sort of standard 2x2 matrix that all people in business schools love so much, if we're thinking of people with levels of high concern for themselves but lower concern for others, we might think that they're going to be taking a more aggressive or coercive approach. So this can be good in some circumstances if we need a very quick resolution to some kind of conflict. So, for example, if it's a health and safety issue, it might be that this is a necessary way using those coercive approaches to actually get people to resolve those issues. Collaboration is that approach where we have high concern for the self and for other, and this is definitely what Fruitco wanted to be occurring with their processes. They were really hoping that people would have high levels of collaboration, that they would be able to find some kind of way of working through those problems themselves without involving a third party or managers or something like that. So this was really the ideas behind that, was that by having self-managed workers, they would have much higher levels of collaboration. Accommodation would be the approach where we have low levels of concern for the self and high levels of concern for the other person. So we might expect this to happen where workers have lower levels of status or lower levels of power. And then finally, an approach where people have low levels of concern for themselves and for others. We might expect more of an avoidance approach, or perhaps triangulation, so bringing in a third party to be able to resolve those issues. And that was definitely what Fruitco didn't want. So what they were trying to do was remove responsibility for resolving these conflicts down to the parties who were involved and getting them to work it out themselves. The manager, the owner, certainly didn't want to be getting involved in any kind of conflicts. Now, based just upon the semi-structured interviews that we had, we spoke about some of the different conflicts that people had experienced. So a lot of this was based again upon the observational data. We could think about ways in which that might occur. We had, out of all the conflicts that we discussed, 5 of these were relationship based, so a fairly small proportion, and all of those were reported by the permanent workers. So we didn't actually have any relationship based conflicts reported by the seasonal staff. There were 29 though task based conflicts, so that was the real issue that the organization was having. Now, splitting it down into that sort of dual concern model, we can think about the way that they were resolved and also the differences between the permanent and the seasonal staff. So thinking first about that aggression or coercion type approach, none of the seasonal workers reported that that was an approach that they used. However, it was over half of permanent workers who said that this was the approach that they were using to resolve the issues that they had. So as examples of that, we might find that workers were being forced out. We were finding to the extent of physical fights going on in the plant as well. In terms of collaboration, so this is what the organization actually wanted. There was a really big difference between permanent and seasonal employers. So around a quarter of permanent employers reported that that was the approach that they were taking, and 3/4 of seasonals. Okay, so there's a really, really big difference there based on contractual status. In terms of accommodation, this wasn't really used by either party. A couple of seasonals reported that, mainly because they were unaware of the process, so they deferred to the permanent workers. And the avoidance or triangulation approach was pretty similar, so around 20% of both groups. See, I've got a cheeky little message there from Brad telling me I've got 5 minutes to go. Well, I think that came up a minute, so 4 minutes to go. So then, what can we sort of draw quickly in 240 seconds together about this? The organization certainly had attempted to redistribute power throughout the organization, and one way they had done that was removing these status differentials. However, what we found certainly with the informal observations and just spending time with the organization was that there was still these real sources of power that people had, and particularly there was big differences between the confidence of the permanent employees as compared to the seasonal ones. So the seasonal employees in general wanted to try and avoid any kind of conflict because they wanted to be re-employed the next year. So we had a much higher use of aggression or coercion amongst the permanent workers. And one thing that was really interesting when we went through the training programs was that it was the permanent workers who got an awful lot more training in trying to take this more collaborative approach and a self-managed approach towards conflict resolution. But it was them who were less likely to have concern for others and more likely to take the aggressive approach and not take the collaborative approach. By contrast, the seasonal workers had a very short induction or onboarding process, and the stuff around self-management in general, but self-managed conflict resolution in particular, was dealt with very, very quickly by them. But they were much more likely to actually use that approach when trying to use conflict. So there's a bit of a deficiency there in some of the training. So as a sort of concluding couple of comments from that, there have been attempts to sort of devolve power throughout this organization, but it led to really, really different experiences of that conflict resolution. The permanent workers certainly were drawing upon the increased levels of power they had, certainly the confidence that they had around their contractual status to take much more of an aggressive or coercive approach. And the temporary workers were much more likely to take that more collaborative approach. I think that will put me pretty much in my 15 minutes. So thank you very much for everyone around the world who listened to that.
Great, thank you, Benjamin. Now you left some time on the clock, which is great because it'll leave more time for questions. So next up we have Jonathan Sal. I'm sorry if I'm mispronouncing your last name, who will be presenting Conflict at Work and its Resolution, a comparative study of some recent developments in labor law in Malaysia and the Philippines. So Jonathan, the floor is yours.
Thank you very much. Let me just set up this. Okay, so yep, the state help and self-help traits of labor law are expounded by Thomas Kohler. State help rules pertain to individual labor laws protecting individual workers, while self-help regulations relate to collective labor laws involving organized workers and collective bargaining. Within the common law, civil law spectrum of labor law systems, Kohler differentiates the American common law labor law approach that has strong self-help aspects to the German civil law labor law model with its robust state help qualities. Among common law labor law systems, Christopher Whelan distinguishes between the United Kingdom's fairly thorough rules about individual labor law and basically laissez-faire voluntarist method of collective labor law, and the American technique that is rather sparse in terms of federal individual labor law, but quite detailed as to auxiliary regulations in collective labor law. In view of their past colonial experiences, Malaysia's legal system and that of the Philippines have had influences traceable to the UK and US paradigms respectively. And here's some questions that I'm delving into in this research, and by way of a descriptive, a description or descriptive analysis, what are some similarities and differences between the systems of Malaysia and the Philippines in regard to conflict at work and its resolution, and then the role of the state, and how are collective and individual labor disputes managed or resolved? In other words, what mechanisms are involved? And by way of explanatory causes or reasons, what are some factors that might account plausibly for these similarities and then differences? A bit of history and law there, but if there is time, but I doubt it given the limited time that we have. And this is, one of the frameworks I'm using, a simple one at that. It's a 2x2 diagram which shows the dispute handling mechanisms. A matrix, so you have quadrant 1, which pertains to voluntary dispute management mechanisms, and quadrant 2, voluntary dispute resolution, quadrant 3, compulsory dispute management, and quadrant 4, compulsory dispute resolution. So it's here I attempt to map out basically the two systems modalities or mechanisms for managing and resolving disputes. So when we say voluntary here, it's based on consent or agreement, compulsory by directive of law or rules. Dispute management involves the parties disputants themselves deciding whether to agree or not agree to settle their dispute, even if it involves a third party, like, of course, a conciliator, mediator, who does not render any decision, order, or award. And dispute resolution involves the third neutral third party who renders a decision based on her or his appreciation of the evidence and arguments of the parties. And here are some similarities, perhaps in terms of self-help dispute management. Broadly, the text of the law in the two systems tend to promote bipartite negotiations first before tripartite methods like compulsory arbitration. Contemporary collective bargaining as a bipartite process articulated in the laws of Malaysia and the Philippines involves three basic phases: representation, bargaining, and administration. And this diagram below shows the flow of single enterprise bargaining from representation through bargaining proper and administration. Representation means, well, basically that's the stage where the authority or capacity to represent, bargain for the constituent is determined. Bargaining, the actual process of bargaining about interests over and above minimum terms or conditions based on law, and that's from proposals, counter proposals, up to approval, registration of the agreement reached by the parties. And then administration, this involves the implementation and interpretation of the agreement of the parties, and this would usually entail mechanisms for bargaining about rights and grievances. And some similarities as well in terms of state help dispute resolution. In actual application or practice, however, compulsory arbitration as a state help approach to worker dismissal disputes is the most utilized handling mechanism in both the Philippines and Malaysia, largely because of the low trade union density and collective bargaining coverage in these two countries. In both cases, compulsory arbitration is handled by administrative instrumentalities with quasi-judicial powers, such as the labor arbiters, the NLRC, the National Labor Relations Commission, and Secretary of Labor and Employment in the Philippines, and in Malaysia, the Industrial Court. There can be judicial review of compulsory arbitration in both countries, which tends to suggest the common law tradition that judicial action is an inherent power. And here's a snapshot of some disparities in terms of single enterprise collective bargaining and the role of state agencies. Again, you can see here the three columns indicating the three stages: representation, bargaining, and administration. For the Philippines, union formation and registration is not compulsory, unlike in Malaysia, where the Trade Union Act 1959 requires registration of unions with the Director General of Trade Union. But in the Philippines, for the unions to be able to exercise rights and enjoy privileges of a registered union, it must register. And one of those rights would be to participate in arbitration or mediation arbitration by the Bureau of Labor Relations or Department of Labor and Employment Regional Office of inter-union disputes via secret ballot or what's referred to as certification election, involving registered union or unions to determine the sole and exclusive bargaining representative or agent, and which this may be appealed to the Secretary of the Department of Labor and Employment. That will be the process unless, of course, the employer recognizes the sole registered union if one is operating within the establishment. But this very rarely happens, if at all. In the case of Malaysia, the procedure for union recognition claim will commence if the employer does not accord recognition and therefore notifies the union in writing of the grounds for not recognizing. And this claim is made through the Director General of Industrial Relations. It may or may not involve a secret ballot. And then ultimately, the decision is made by the Minister for Human Resource. Then these would set the stage for, set up the next stage, that is, which is a bargaining proper stage. In the Philippines, there's a duty to bargain collectively in good faith upon concurrence of certain jurisdictional preconditions. Number one, a demand to bargain by the union that possesses majority status, that is having won the certification election by a majority of the valid votes cast. And of course, proof of that status. So those are the jurisdictional preconditions that would trigger the process of collective bargaining. But once those are present, then it becomes a duty to bargain. But there's no such duty in the case of Malaysia. There's voluntary commencement of collective bargaining. And if for some reason the parties fail to commence collective bargaining, then the Director General of Industrial Relations takes steps to bring the parties. It's sort of some sort of mediation effort. And then, the two countries also differ in terms of industrial action matters. The Philippines follows pretty much the U.S. model. In Malaysia, when there's a strike or lockout, it goes through compulsory conciliation conference by the Director General of Industrial Relations and or the Minister for Human Resource. And the agreement in the Philippines is registered with the Department of Labor and Employment once, of course, that is voted upon by a majority of the employees in the bargaining unit. And in Malaysia, the agreement is recognized by the industrial court, which considers it in effect an award. And in the last stage, once the parties, of course, have a valid and binding agreement because it has been recognized pursuant to the requirements of the rules in the Philippines, when there are questions or controversies regarding interpretation or implementation of the CBA provisions, it will go through grievance machinery and eventually voluntary arbitration if the grievance remains unresolved. Let's say it's a hybrid process, which highlights the nature of the process as part of industrial self-governance. And when there are alleged gross violations of the CBA provisions, then it goes through compulsory arbitration by the National Labor Relations Commission. In Malaysia, only grievance machinery is compulsory, although the parties may incorporate in their agreement a voluntary arbitration clause, but that's up to them. Like in the Philippines, it's a mandatory clause. And if the parties agree, they could also have a voluntary mediation of any unresolved trade dispute, like a strike, lockout, and grievance by the industrial court. And here, some more disparities in terms of, the term of the agreement, the lifetime of the agreement. And you can see here that the Philippines has two terms, one a 3-year term with respect to the economic and non-economic provisions, other than the status of the union as EBR. And there's that 5-year term as to the status of the union as EBR. Malaysia is not as complex. It has a 3-year term from the commencement of the agreement, and the agreement must prescribe the process for its modification and termination. And the diagram here indicates that process of that reflects the terms and lifetime of the agreements. And you can see here that in the case of Malaysia, once the 3-year period expires, they commence renegotiation. And the Philippines can also go through that, but of course, with respect to the EBR status, it has a 5-year period, and they will go back to the representation aspect or phase or stage of the process. And then some disparities in terms of compulsory arbitration. Well, in a nutshell, there are two categories: state help compulsory arbitration and self-help compulsory arbitration. But you can very well see that Malaysia's system is quite more simple and more centralized, in the sense that it's all done by the industrial court, case of dismissals. But what's important here is that the Minister for Human Resource makes a referral of these disputes to the industrial court, whether it's a worker dismissal or in case of unresolved trade disputes and grievances. The Philippines is more complex. It involves, well, basically three state agencies: the Labor Arbiter, the National Labor Relations Commission, and National Conciliation Mediation Board in case of state help compulsory arbitration. And then in case of self-help compulsory arbitration, it's also three. You have three agencies there: the Labor Arbiter, the NLRC, and the Secretary of the Department of Labor and Employment. We can skip those. And well, in conclusion, the Philippine system is clearly more adversarial and complex, largely because of, for one, because of its inter-union representation disputes, which is patterned after pretty much the US model. It's more decentralized, and Malaysia's system is less adversarial, complex, and more centralized, mainly because of the expanded compulsory arbitration powers of the industrial court. And I can end on that note. Thank you very much.
Okay, thank you, Jonathan. If you could stop sharing your screen.
Okay, yep, thanks.
Yeah, thank you. So it appears that we have close to a half an hour to open this up to questions. So I would ask that if you have a question, either you use the raise hand function and then I'll call on you, or you can also type it in the group chat box. So is there anyone that would like to start? Okay, so I guess maybe my hand will be forced here. And so I could ask a couple of questions. And so I guess for the first two presentations, I'm still trying to think this through a little bit in my head, but in terms of the mandatory arbitration clauses and the companies that are adopting those, I did wonder if you account for like where they're headquartered, if that matters at all. Obviously, I'm coming from a little bit different perspective here in Canada, where we very likely, it hasn't really been studied, but very likely don't have as much mandatory arbitration clauses. That's not to say that we don't. There's a very high profile case going on right now regarding a mandatory arbitration clause for independent contractors, as they see it at Uber. But, you know, and Uber's forcing them to undertake that arbitration in Europe. We just recently had Foodora leaving. You know, it seems like these tech companies that are looking to take advantage of workers, whether or not they're actually employees or not, many of them are not Canadian companies, are not headquartered in Canada. I wondered if there's so any indication that the companies, you know, are they headquartered in the U.S. and it is U.S. companies driving it? Or is it U.S. companies that are taking advantage of being headquartered somewhere else? Is that kind of an indicator? And I actually had you know, a similar question then moving on to Deborah and David's. Likewise, does your survey account for where you know, is it potentially US companies that you're saying kind of more of that movement towards integrated conflict management systems because it's most developed in the United States. Again, from my vantage point in Canada, I would, hypothesize that likely those who are using, going back to the mandatory arbitration clause, it's actually US companies or at least, maybe not US companies headquartered in the US, but like Uber, pushing kind of the adoption of that. So I wondered if your survey, if you account for perhaps where the company's headquartered.
I can jump in that we do have that actually in the data. 5% of the respondents were owned by a foreign company. We didn't specify beyond sort of US, non-US, but we haven't run that analysis yet. But that'll be interesting to kind of look at. We'll try and break that out. It's a small percentage, so, overall, so we may not, get much statistical power there, but it'd be pretty interesting to look at that.
Yeah, and I can just give the same response that Alex just did for the UK study, that we have asked about nationality of ownership. We break it down. I think there's about 5 or 6 different categories, but we haven't got around to kind of crunching the numbers around those distinctions. I think from memory that we don't have huge numbers of respondents in the kind of, especially in the US owned corporations kind of section, so it may be hard to find significant difference, but it's certainly something that we'll be exploring as we analyze the data set.
And Brad, just to build on your question and Alex's response, you were referring to sort of US, non-US, but there are also likely interesting dimensions too within the US location. And those are additional analyses that we
right.
doing as a sort of structural feature driving mandatory arbitration.
Sure. Whether that be location or I don't know, just headquartered in Delaware where you can have tax advantages, right? I mean, just a thought. Yeah, David, do you want to?
Yeah, thanks. Let me just take my hand again. A question for Ariel and Ryan and Alex. I was really interested in the idea of adding in strategic choice kind of framework and the idea of kind of looking for evidence of support for mandatory arbitration amongst high road and low road organizations. And your conclusion seemed to be that it's a bit more nuanced than that. I wonder if you could kind of explain a little bit more what you mean by that. Do you mean that there's evidence that both types of organization show support, or that actually you can't categorize the responses as purely low road and purely high road, and they kind of use elements of both approach, if you like?
Great, so I'll start and then turn to Alex and Ryan. So just a couple of clarifications. Thanks so much for the question, David. So theoretically, we're motivated by this question. Is this primarily low road firms? We've talked between us sort of the Walmarts of the world that have a whole host of sort of low road employment relations practices, and they add to that a mandatory arbitration practice that limits employees' ability to go to court. Or, as might be suggested by some of the more sort of favorable arguments about mandatory arbitration, that this is actually for more of a high road practice that complements the use of high road practices for high skilled, high waged employees that have a little more bargaining power. And so those are sort of competing hypotheses about what's driving the use of mandatory arbitration. And when we sort of first started to look at this, I guess we each had our own sort of priors, but there was somewhat of a sense that this would be primarily driven by low road firms making use of mandatory arbitration, primarily because of the tone of the debate around the use of this practice and what it does for employees' access to the court system. And what our findings suggest is that that story is nuanced, that there are firms that have high paid, highly skilled employees that make use of mandatory arbitration. And then there are firms that sort of go what Alex has termed sort of a long-term low road strategy, because it's also nuanced within the low road approach, because what we find is low wage employees, but low turnover, which is sort of a combination. And so again, the evidence suggests that the underlying organizational logics for use of mandatory arbitration are more nuanced than either of these two sort of approaches might suggest. So I hope that helps clarify, and then again, I'll turn it to Ryan and Alex.
Yeah, just to reiterate there what Ariel was saying, I just shared that interaction effect, which is in part, I think, driving the high road story. But another element that's driving the sort of high road aspect of our story is, you know, I think we would have expected to see high turnover firms. If it's a purely low road story, we'd expect to see, you know, high turnover firms maybe also having these practices, having mandatory arbitration at higher rates than the sort of long-term story, long-term low turnover story. The fact that we find a main effect of high turnover actually being negative seems to suggest to some degree maybe a higher road story. And also I would maybe make the argument that the fact that we have such a strong union effect as well suggests to some degree a higher road story as well, a sort of union complementarity story, and a story that says that you know, when you have sort of the protection of a union, that might spill over into your non-union managerial workforce in a way where, you know, mandatory arbitration may not necessarily be a substitute for union status. And so, you know, from my read of our analysis so far, those seem to be pretty good drivers of a high road story, as well as in the main effects, as well as the interaction terms. I don't know if Alex if you had any other thoughts as well.
Yeah, just kind of add on this. One thing that is important to understand, I think, is that higher wage strategies make for higher costs of conflict resolution, you know, if you've got high wage employees with longer attachment, if those are the employees who then lose jobs and there's a conflict, right, that produces much higher litigation costs, right? So in some ways, right, it's sort of a you know, complement to a higher road kind of long-term employment strategy, in the sense that companies still want to protect themselves, right, from litigation. So it's a defensive approach in that sense, but it's sort of effectively a cost that comes with being a kind of higher wage, more stable employer because, you know, those are the people with long-term employment. I was also going to mention while we were talking, I quickly ran that international HQ'd company thing, and it's slightly lower adoption of mandatory arbitration for foreign-owned companies, but it's not significant, at least in the quick bivariates that I ran. So yeah. So along that story, but we're probably, unless we get some special regression results, we're probably not going to find significance to it.
Thanks, Al. Yeah, thanks, David, for the question and for those just-in-time regression results. So we do have a question in the chat box from Bob Hebden for our first panelist, and he asked, how is mandatory arbitration viewed by employees in the US? Any research on this?
So, I see Alex wants to respond. I have a tangential response.
Yeah.
So I'll sort of take just a little tangent. There is some evidence, data collected by Zev Eigen, who did research on mandatory arbitration, about how much employees actually understand and know about mandatory arbitration. So not exactly their perceptions of, but it's related, because they understand that his evidence suggests that there's a very weak understanding of what mandatory arbitration clauses that employees sign actually mean, and what do they require them to do when a conflict, a dispute arises. So that, you know, so to your point, Robert, the first piece is, do employees even understand what it means to have a mandatory arbitration agreement? And there's some evidence to suggest that they don't. What their perceptions, once they do understand, I'm less familiar with the research on that front.
Yeah, and there's been a couple of studies doing kind of survey type evidence, and they tend to find that employees like arbitration, where it's presented as a voluntary alternative to litigation jointly negotiated with the employer, and they view it more negatively when it's mandatory. So it kind of diverges. So the current structure in the US is almost entirely mandatory, non-negotiated, in which case it's viewed more negatively. The one exception would be executives tend to voluntarily negotiate arbitration, and there's research showing that they, stuff I did with Kelly Pike, showing that they do nicely in arbitration. So, you know, if you're a CEO, feel free to negotiate your own special arbitration procedure.
Great, thank you. Any other questions?
I have another one follow-up.
Oh, yep, go for it, Bob.
It's not really a follow-up. I'm cheating, but I had a case when I was at Cornell. It's a long story, but Cornell has a great internship program, and I supervised an intern that went to a Wall Street firm who had, and she actually examined the arbitration process there, case of sexual harassment. And the case went to an arbitrator who was a former partner of the firm, a retired partner of the firm. And he awarded some amount in her favor of something like $500, which it had gone to the courts, it would have been tens of thousands at least. So I guess my question is, who are the arbitrators in this process? How do the arbitrators get appointed? Are they from the list, or does the employer have a role in sort of putting this list together, as that case, very long time ago, but it was a case in New York?
I think that's pretty unusual, though not, out of the question that you still see some of that. So Mark Goff and I did a different kind of survey looking at this, where we gathered some evidence on the service providers being used, and about half the time it was the American Arbitration Association was designated in the agreement. It was about 15% JAMS, about 20% other providers, and then another 15-20% were just ad hoc. And so the ad hoc could include that kind of higher due process violation type of procedure. Most often it is these kind of relatively well-known organizations. But that said, it's still the employer who decides whether you're going to be signing the arbitration agreement or not, and who's designated within it, right? So the employer essentially gets to choose whether you go, say, a AAA panel, or you go this kind of ad hoc type of procedure. The example that you give of, I know of sort of really in-house. I know there was at least one case in the US where they tried to designate the vice president of human resources for the company as the arbitrator. And that was actually not enforced because it was held not to actually be arbitration. So as sort of by definition, that isn't a neutral arbitrator. It's just you making the decision, right? So that didn't count. But, you could imagine other kind of sneaky ways of doing it, where it's sort of a really, cook, not a real arbitrator.
Thanks, Alex.
Great, thanks, Bob. Thanks, Alex. John has a question, so John, you can go ahead.
I have a question for Jonathan. And so I'm wondering, is there any feature of the country's systems that seem to be particularly innovative or high functioning that might be worthy of consideration for adoption elsewhere?
Yeah, I was not able to incorporate in this presentation some other dispute management mechanisms. In the Philippines, there has been, of late, a new model of conciliation mediation that is considered state help, in the sense that it addresses individual labor disputes. It's different from the conciliation mediation that has been in place for quite some time. That's been handled by being handled by the National Conciliation Mediation Board. This is with respect to individual labor disputes that are brought to the single entry approach that was created through a Republic Act in 2013. I think it's important in the sense that it addresses a gap. The trade union density in the Philippines has been going down, I guess, as that's happening worldwide, of course, and the collective bargaining coverage is very low, and so pretty much the mechanisms that are connected to those that I've discussed as well earlier, connected to collective bargaining as a process, are hardly being used, and so this new mechanism, it's called single entry approach, is something that well, I guess is worth looking into, perhaps by other countries, but of course there might be in place in other countries systems of this nature as well, but yeah, that's one mechanism, I think, that is in the case of the Philippines is quite innovative. It's a new one, introduced, well, first in 2010 as a pilot, using the Secretary of Labor using her powers to come out with implementing rules and regulations, and then eventually strengthened through legislation that was introduced in 2013. So, yeah.
Great, thank you, Jonathan. Ariel has a question for David and Deborah, so I'll give him the floor.
Thanks so much, Brad. A question for Deborah and David, and then for Benjamin, if possible. For Deborah and David, thanks for your presentation and for the insightful empirical evidence. I wanted to know, I guess this is sort of a conjecture kind of question, but Deborah, your conclusion was that you're sort of on the way towards an integrated conflict management system, that there's cautious evidence to suggest that that's the case. What are some of the factors that might hinder or enhance the likelihood that sort of full transformation might take place? And then for Benjamin, I was wondering about outcomes associated. You so clearly outlined the differences associated with the two industrial relations systems, but what are some of the consequences or outcomes associated with these very clear differences in complexity and the adversarial nature and so forth? Thanks.
I'm looking at Dave and he doesn't seem massively keen to step forward and take that one, so I'll take it. I think if you go back to look, and feel free to jump in at any time, Dave. If you go back to look at the elements of ICMS that are evident within the UK, one of the things that's broadly absent is the kind of conflict competent culture. So one of the questions that we did include in the survey was to try and get at people's perspectives on culture, and by and large they were very strongly unitarist within the UK, or at least the companies that responded. So I guess one of the largest factors within the companies we surveyed in hindering that kind of full-on development is this move to the perception that actually conflict is not always necessarily a bad thing, and if you put mechanisms in place to support it, actually it can be beneficial towards your organization. I don't know if you want to add anything, Dave.
Yeah, I mean, I think the other thing to say is that the data already shows that, that there is a gap between what firms say they've practiced in the last 3 years and what they have in their policies. And I think I think the thing we're struggling with or kind of grappling with is how you define what an ICMS is. But if you define it as a kind of quite procedurally coherent set of policies, then it's not perhaps a surprise that the firms who don't in paper on paper rather, say that they have very many elements of ADR, even that they don't have, therefore that they don't measure or record that they have an ICMS. I think there is a kind of an interesting analysis to unpick about this kind of gap between what they say that they do and what they actually do. And I think, it may be we need to kind of think about what are the essential elements of an ICMS, and is it about practice as opposed to sort of policy? Because then it may be that you could say that there is evidence, as we said in the presentation, that organizations are linking their conflict management to wider HR strategies and goals, but perhaps not at a kind of formal policy-driven level, which accounts for that kind of disjuncture, if you like.
Thanks.
Yeah, I can comment on the question there. The outcomes for seasonal workers in general were exit. So that was either if inevitably there'd been some sort of physical altercation in the workplace, it tended to be that either both of those workers would be dismissed if they were seasonals. If there was a permanent and a seasonal, it would be the seasonal who would be going. And as well, it tended to be if there was any kind of issue for seasonal workers, then they just wouldn't be re-employed the next year. So they would have a note on their HR form, and they just simply wouldn't be re-employed the next year. So because the company paid quite high wages, not only for the state that they were in, but also as compared to sort of competitor organisations, they didn't really struggle to be hiring people. So any kind of being seen as a troublemaker meant that you weren't going to be re-employed the next year.
Great, thank you. Benjamin, we got another question in the chat box for you. So Annalise asked, you noted interesting differences between the permanent workers and seasonal migrant workers and their approaches to self-managed conflict. Are you aware of any research on seasonal migrant workers and differences in group dynamics based on intragroup power dynamics and whether they relate to employment status or cultural factors? Do your findings tend to hold across different settings? Have there been any longitudinal studies that might show trends in conflict resolution approaches as greater stability in employment is achieved? So packed a couple questions in there, but if you want to tackle any of those, that'd be great.
Yeah, so in terms of any research on group dynamics amongst migrant workers and temporary workers, obviously my own fascinating stuff around intra-European migration, which looks at some very different groups of migrant workers from across Central and Eastern Europe and what happens when they move to the UK, and how they work both their colleagues who tend to be migrant workers as well, and how they sort of drop in with permanent tending to be native workers. So in terms of the findings holding true across different settings, if you've nothing better to do on Saturday, I've got another paper which is looking at informal hierarchies within this organization. So there you go. I've just ruined your weekend. You'll have to come along to that one on Saturday.
Okay, thank you, Benjamin. I think we have time for one more quick question, maybe from Ryan.
Yeah, I just had a question for David and Deborah. It's to some degree a comment related to both Brad's point and also to the comments that you just made in response to Ariel, which is, your findings are really interesting when you think about the contrast between your results and the results that we might see in the US context. So in your context, it seems to be a story of, maybe informality, not formal uptake, but, practical uptake instead. In the US, it seems to be sort of the opposite to some degree, where conflict management systems are written into formal policies and procedures, but are maybe adhered to in a less sort of policy-oriented way. They're sort of given lip service or what have you. I wonder if, this isn't really an easy question to answer, but maybe just food for thought. Is there anything that we can think about that might explain why we see these sort of contextual differences emerging, and this might relate to Brad's point about, you know, maybe the sort of organizational characteristics or cultures, or something around, you know, maybe multinationals or something like that. But I'm just curious if you had any thoughts on, or if you've been able to think about, you know, why your results look quite different contextually from results elsewhere, or if not, that might be something that you might want to explore or think about a little bit. Yeah, just a sort of general comment.
Thanks, Ryan. I mean, it's interesting. That's exactly the conversation. Ariel and I have had this conversation on at least 2 occasions, starting at the ILERA conference last year, and I was over visiting it later last year, and we didn't really come to any kind of firm conclusions other than sort of commit to kind of try and pick out the data a little bit more and see if we can explain it. I think one possible explanation might be the different, if you like, threat of litigations, if I can put it that way, in both countries. I think in the UK, although we're moving towards that direction, there has been movement towards kind of greater legal redress, if you like, of conflict. It's still much lower levels than in the US, and the associated costs are much lower as well. So I think that would be one institutional difference. I'm not sure, I mean, if Debs would agree. I mean, the possible role of the kind of the institutions, things like ACAS, and they're not just in terms of resolving disputes, but they're kind of extensively involved in, you know, offering advice and that kind of soft kind of dispute resolution services that I'm not as familiar with the US system, whether there's an equivalent body in the US that kind of fulfills those kind of those roles. But I agree. I think it is really, you know, really interesting why that there seem to be, on the surface at least, a flipped image of formality, or of kind of, you know, of what's written in formal policy and what organizations report having used in actual disputes in the recent past. So I think it's something to explore and try and explain as we go forward, I think.
Yeah, I'd agree with that. The only other thought that kind of crosses through my head as Dave was talking is that there's a general absence in the UK, that, you know, general absence of mediators, more generally lawyers, that something has to fill that gap. So the formal isn't there, so the informal just kind of moves into it, I guess, would be a potential explanation as well.
Thank you.
Okay, so we're 2 minutes over here, so to give everyone a break before the next sessions, we'll end it there. Thank you to all of the panelists for the very interesting presentations, and thank you for the very insightful questions. Everyone enjoy the remainder of the conference. Take care.
Thanks, Brad.
Thank you.
Thanks, Brad. Thanks for sharing.
Yeah, thanks for sharing. Yeah, great job.
Yeah, that was great. Thank you.
Thank you very much.
Yep.